Hello, and today we're looking at the tort of defamation. So I began with my introductory video where I distinguished between libel and slander and the different implications they have. So a tort of defamation is where you cause loss to somebody's reputation by producing a defamatory statement about the claimant to a third party. So essentially there are three components. You have to ensure that the statement itself is defamatory, so we had a look at that with the true meaning and the innuendo. Then it must refer to the claimant, so what are the issues surrounding that? We had a look at it. And now it must be published to a third party. So when we're looking at whether it was published to a third party, who is this third party? A key running theme is the person who is capable of understanding the defamatory statement. So when we were looking at whether the statement was defamatory, it's the idea that was the reader capable of understanding it. In whether it refers to a claimant section, we were looking at would reasonable people attribute this statement with the claimant. So here again, when we're looking at it's published to a third party, it must be the third party who is capable of understanding the defamatory meaning and actually in fact refers that statement to the claimant. And the next thing to see is whether it was in fact published to a third party is to look at foreseeability, a key principle in tort. So we can compare the cases of Thieker and Richardson 1962 and Huth and Huth 1915. In both these cases, a letter was posted to the claimant, but in fact somebody else read it. So in Huth and Huth 1915, the butler read it. This was unforeseeable. Therefore, there was no publication to a third party because it could never have known that the butler would read it, and therefore no claim in defamation could be established. Whereas in Thieker and Richardson, the husband in fact read the letter. So here we have policy issues surrounding, gender and, the idea that a husband can look at the wife's property and all that also. But the key point was, in 1962, the courts deemed it foreseeable that a husband would go through his wife's post. And so for that reason, it was published to a third party being the husband, and a claim could be brought. Then we need to also look at particularly internet service providers. So in the case of Bunt and Trilly 2007, in an internet bulletin board, they couldn't be held liable for the comments that were put on this bulletin board because they were merely acting like a distributor as opposed to the publisher, that they weren't even aware of it. So the claims were struck out. Now we can compare this to Godfrey and Demon, where the internet service provider had known about these comments for 2 weeks and known that they were defamatory and didn't and refused to take them down, and therefore that gave rise to a liability. So that's the case for internet service providers. And similarly, we can look at the case of Slipper and BBC 1991. So the defendant knew the film was likely to be reviewed by the national press, and several attempts were made because this film featured a claimant who was basically being portrayed as a buffoon, essentially. So he sued on the film, and he sued the BBC. Now the BBC tried to argue that, like in the case of Bunt and Tilly, it was just a distributor. However, they knew the film was likely to be reviewed in the national media, and it was going to have a defamatory sting to it, and so it could be attributed to the BBC. Again, we're looking at principles of foreseeability as we were looking at with the letters. And then in this case of Magmanus and Beckham 2002, well, there's no kind of resolution because it was settled out of court, but essentially Victoria Beckham went into a shop and she said, oh, this is fake, looking at something to do with David Beckham, and then that hit the media, and the shop suffered a reputational loss, as you would imagine. And so they were looking at, was she actually to be attributed for the publications which actually caused the loss? We won't actually know, but I mean, I don't know. I haven't really come to a conclusion on what would actually happen, but it's an interesting scenario you may wish to mention. But the key thing is, with the Defamation Act 2013, when we're looking at all these cases like a Slipper 1991 and all these things, before, however many times a defamatory statement was made, each time gave rise to a new action in tort. Now, this has been replaced with the US model, where you have a single publication rule, as specified by Section 8 of the Defamation Act 2013, where you can only sue for one publication, not the repetition and the further statements of the initial publication. I hope that makes sense, but you just need to read the statute book for that. And finally, so looking at who can sue, because there are some restrictions onto the tort of defamation. Well, if you're dead, you can't sue. You have to be alive, because it's affecting your live reputation, not your dead reputation. You can't sue as a trading company unless it's to do with your professional reputation. Trade unions, and I don't think if you're bankrupt you can make a claim in defamation either. Even the government is not allowed to sue in defamation. According to Derbyshire CC and Times newspaper 1993, to allow the government to sue for defamation would have a chilling effect on the free public debate that they're supposed to be a part of. Obviously, this was before the European Convention of Human Rights, so this might impact in the way in which government claims are dealt with in the future, but it's likely that they wouldn't be allowed to sue anyway. They're supposed to be there for public accountability. Again, we have public policy reasons coming into play. And yes, individual celebrities, as we've seen, are allowed to bring case of defamation, but so are companies and transnational corporations such as McDonald's, in the case of McDonald's Corporation, and Steel No. 4 of 1995. Thank you for watching.